A law is an opinion backed by a gun. That's it, folks. That's all it is. The rest is just political window dressing, as I will show. For example, a statute is just another fancy word for a law. Even a judge's opinion are called the law. Lawyers call this discretional law. Lysander Spooner said it best. What then is legislation? It is an assumption by one man or a body of men of absolute irresponsible dominion over all other men whom they can subject to their power. It is an assumption by one man or body of men of a right to subject all other men to their will and their service. It is an assumption by one man or body of men of a right to abolish outright all the natural rights, all the natural liberties of all other men, to make all other men their slaves, to arbitrarily dictate to all other men that what they may and may not do, what they may and may not have, what they may and may not be. It is a sort of, in short, the assumption of the right to banish the principles of human rights, the principles of justice itself, from off the earth, and set up their own personal will, pleasure, and interest in its place. All this and nothing less is involved in the very idea that there can be any such thing as legislation that is obligatory upon those upon whom it is imposed. Lysander Spooner. Natural law, or the science of justice, a treatise of natural law, natural justice, natural rights, natural liberties, and natural society, showing that all legislation whatsoever is an absurdity, a usurpation, and a crime. Part first. Lawyers, not me, define a statute as the written will of legislative department. Ballantyne's Law Dictionary, page 1212. The lawyers doing business as the United States Supreme Court hold the same belief. See Johnson P. King, MFG, Co. versus Supreme Court. Versus Council of Augusta, 277 U.S. 100 at page 102 to confirm. Simple observations show us that, factually, a so-called legislative department is just men and women. If not, then what is a legislative department? Rock, flour, puppies, reptiles, raisins? It follows that so-called law is just a written will of men and women. We should not forget this. Written will differs from mine in that I don't force my written will on anyone under any pretense of protection, and most assuredly not at the barrel of a gun. Does the law seem as sacred to you now? Don't confuse a political law with a natural law, such as the law of gravity. The law of gravity is not the invention or whim of a man. It's an observation. Just as important, when was the last time you were forced by another person to comply with the law of gravity? And why is that? Amazing. The earth rotates on an axis every day without a sacred act of Congress. In my experience, no judge has admitted or acknowledged the so-called law is just a written will of some individual, even when he is made aware of it. Pay no attention to the man behind the curtain. That's why I request what is called judicial notice. I request that the judge take judicial notice the statute I was charged with breaking is factually the written will of an individual man or women and women. No judge has ever complied with this, despite the fact taking judicial notice is mandatory under the rules of evidence in Arizona, and in the federal courts it's Rule 201D. In California it is under subsection 451 of the Evidence Code. Try imagining why an alleged benevolent, honorable protector of the people would refuse in every instance to take notice of what law really is. Why the refusal to comply with a mandatory function of his exalted office? Then consider this. Then consider this happens in every instance, no matter what the geographical location. What are the odds? What are these honorable lawyers afraid of? It's called the three-monkey defense. Hear no evil, see no evil, speak no evil. When confronted with the truth, judges are non-responsive. Their sacred law isn't so sacred when it's just written will of some men and women. I ask for judicial notice of what a pretend law is because the cop is supposed to prove beyond a reasonable doubt this so-called statute created a duty on me. If the judge takes notice a statute is nothing but the will of a group of men and women, then the cop has to bring forth the facts he relied upon to support his opinion. Their will created a duty on me to act or not act in a certain way. The cop is pretty ill-equipped to do this because his traditional accoutrements, gun, stick, badge, uniform, antisocial behavior, etc., don't help him any. In other words, swift and blinding violence is about as effective here as it is in solving geometry problems. Maybe Congress can pass a law magically transforming everyone into a mathematician. In fact, in every single instance where I have asked a cop what a so-called statute was, they were unable to answer. They just don't know, and lawyers don't think they need to know. Yes, cops won't hesitate to kill you if they think you are a violator, but while they are killing you, they cannot tell you what you are allegedly violating. Has this created any reasonable doubt in your mind yet? This cop is certainly not in a position to testify he saw me violate a statute when he doesn't even know what it is. Your Honor, I'm the one who discovered the theory of relativity. Really, Officer Carl? What does the E stand for? How should I know? That's irrelevant, Your Honor. I agree. During one trial in Arizona, I asked a cop if he knew what a license was. He admitted he didn't know. I suggested that since he didn't know what a license was, that he was in no position to testify. I was required to have one. He was in no position to testify that I was required to have one. What did the judge do with the robe? That's right. The Judge Donald bailed his buddy out. He asked, "Officer, do you know what a license looks like?" "Yes, I do, Your Honor." The judge responded, "That's good enough for me." Not surprising that the appellate court, yet another lawyer who is now a federal judge in the Ninth Circuit, ruled she saw nothing wrong with what her fellow politician did. The judge is not supposed to have any discretion to permit such an individual to testify because 602 of the Arizona Evidence Code states, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. If the cop doesn't know what a statute is, not what one says, but what it is, then he has no personal knowledge of the matter and may not testify unless, of course, personal knowledge is now synonymous with gun, badge, and a willingness to kill men, women, and children for not following orders. If this cop doesn't know what a so-called statute is, then it's impossible for him to prove beyond a reasonable doubt I allegedly violated one. This is much easier to understand if I don't use the word law. Instead, I'll use XYZ. So you are not hypnotized by the word law. This guy is so unbelievably poignant in his points. Here we go. Cop, Mark, broke the XYZ, Your Honor. Mark, okay, if you say so, but what is XYZ? Cop, I don't know, but you broke it all right. Would you rely on this guy's testimony? Traffic court judges do it every day. It's no different if accused of breaking the law by a man who doesn't know what the law is. I once worked on an IRS case with a lawyer. We initially lost the case, but the judge used the Constitution as grounds to throw the complaint out. We filed a motion to reconsider and requested the judge to take judicial notice the Constitution was a written instrument. This fact was supported by observation and by the lawyers doing business as the Supreme Court. The Constitution is a written instrument. State of South Carolina versus U.S. 199 U.S. 437, 1905. See also McSinney versus Ohio Election Common, U.S. 1995, number 93986, decided April 1995. This judge refused, although it's mandatory under Rule 201D of the Federal Rule of Evidence, without disputing the truth. She claimed that the facts were inappropriate. Susan's decision was based on the Constitution, but what the Constitution literally is was somehow inappropriate. Yes, Virginia, there's a Santa Claus. If you don't acknowledge what it is, you may as well as substituted XYZ for the law or the Constitution. Tell me exactly what the Constitution or the law is without using the word Constitution or law, and you'll see what I mean. Nowhere in the Federal Rules of Evidence can I find where a judge can refuse to take notice of facts because they feel it's inappropriate. Relevant, yes. Inappropriate, no. Couldn't the facts be of a brutal rape or a murder be considered inappropriate also? You may be asking yourself why a judge would refuse to take judicial notice of what the Constitution is. Factually, especially when he or her entire decision is based on it. After all, judges take a pretend oath to preserve, protect, and defend the Constitution, and yet they run sometimes literally when asked to take notice of what it is. Why is that? I think it's because they know or are realizing they cannot prove the Constitution created any obligations on anyone. Can you explain how 200-year-old unsigned written instrument transfers property rights? The same thing happens when I ask notice be taken. The law is the written will of a group of individual men and women. Bureaucrats do not like talking about how and why and what they call the law allegedly became obligatory, binding, or how and why it created some pretend duty they are accusing me of somehow breaking. It's as if they know it's not binding on me, them, or anyone else, and they are afraid of letting the cat out of the bag. Maybe cops would be less enthusiastic to kill in the name of the law if they knew it was just an opinion. I arrest you in the name of Ted Kennedy. I like to cut to the chase. I may ask, what facts are currently before you, proving when, where, and why, and how the written will of individuals ostensibly labeled legislators became obligatory on me? They are the ones who are supposed to prove their case beyond a reasonable doubt. How is that done without these facts? Can you just assume the law is binding? Yes, bureaucrats do it every day. However, what is the point of a trial when facts are assumed? What about the part about beyond a reasonable doubt? I did a pretrial conference with a lawyer I used to work with. We were in San Jose meeting with two IRS lawyers. The lead lawyer sneered contemptuously at me. What makes you think your clients are subject to the federal law, Mark? I said, what is federal law? She was a bit puzzled by this, though, for a moment, and then said, that's what Congress says. I responded by saying, okay, isn't Congress just a group of individuals, men and women? She agreed it was. I then asked her, what facts do you rely on that my client is subject to the will of these individual men and women? She refused to answer, and her young coworker arrogantly stated, we don't have to prove anything like that. The court will let us. We don't have to prove anything like that, and the court will let us. I then said, okay, let me see if I understand your pretrial position correctly. You are saying we are the IRS and we do not, and we can do and say whatever the hell we want, not have to prove a dang thing, and the court will let us get away with it. Is that right? He refused to answer, and they wound up refusing to return any of our discovery materials, including refusing to attend a deposition. That, however, is typical when the opposition has no case. You see, bureaucrats believe they don't have to prove the law that they ram down people's throats is actually binding on anyone in anything or in any way, beyond a reasonable doubt. Who are they kidding? Bureaucrats don't believe they have to prove their law is binding at all. They believe their fantasy is reality, and it is and if it is questioned, then the person who has the temerity to ask is labeled a wacko or being in an alternate reality. And I agree in regards to the alternate reality. My reality is based on tangible facts, and the bureaucrats' reality, legal land, is based on opinions heard from honorable lawyers and other bureaucrats. This is all just a normal everyday part of legal land. Bureaucrats only need to hold an opinion and a gun, and that's all. What is more, their opinion, the law is binding and or applicable, is a sacred cow, quite literally immune from challenge. The rules of evidence, confrontation, and fairness be damned. And why is that? Yes, lawyers spew forth nonsense such as the courts have long held in defense of their adversary system. Of course, who wouldn't defend their own business? However, legal opinions are not facts. I once had a former IRS district counsel tell me over the telephone that if I were a lawyer, I would be disbarred for challenging a revenue agent opinion the law was binding. Disbarred for challenging a witness's testimony? And why is that, Mr. Former District Counsel? You guessed it, control, to keep the truth from getting out. The truth being, the law binds no one. What would happen if just 100,000 victims of the bureaucratic attacks challenged the legal opinion? Think about it. It's only an opinion. Confidence would collapse. This is why lawyers representing the IRS told me a revenue agent's legal opinion, collectively known as a notice of deficiency, were irrelevant. To whether the notice was correct, apparently the whole is not equal to the sum of its parts. In other words, his legal opinion, including the law created a so-called tax liability, were irrelevant to whether the asserted tax liability was correct. That's the equivalent to convicting a man of rape on nothing more than, he did it, Your Honor, and the honorable lawyer, and how do you know this? Your Honor, I object. That's wholly irrelevant to whether this idiot is guilty or not. This man is a cop, and his official opinion is more valuable than that of an accused rapist. I was in an informal conference with individuals claiming to be the Department of Revenue in Phoenix. I handed the revenue agents her so-called notice of notice of proposed assessment, and asked her if everything on there was true and correct. The response: she and her comrades vehemently refused to answer the question. However, I think rational people would agree that she did answer the question by her actions. But why would people so extraordinarily confident in their so-called assessment refuse to answer this question? Some may argue that whether the law is binding is somehow irrelevant to whether a tax liability is created, that a revenue agent's or cop's legal opinion should not be challenged as any other witness would be. I will briefly demonstrate why this is irrational and inconsistent with the very system facilitating the attack. Real crimes do not depend on the existence of a law to prove they were committed. I'll compare tax evasion with a real crime. Section 7201, attempt to evade or defeat tax. Any person who willfully attempts in any manner to evade or defeat any tax imposed by this title or the payment thereof shall, in addition to other penalties provided by law, be guilty of a felony, and upon conviction thereof shall be fined not more than $100,000, $500,000 in the case of a corporation, or imposed not more than 5 years, imprisoned not more than 5 years, or both together with the cost of prosecution. Title 26, United States Code, emphasis again is Mark Stevens. Notice this pretend crime depends entirely on the existence of some so-called title or law. Without this so-called law, there is no crime. The same is true of an affront to humanity called failure to provide ID. Aren't crimes supposed to be proven beyond a reasonable doubt? Isn't the applicability of the law an essential element here? Can this legal opinion then be assumed by a non-lawyer? Gasp. And not be subject to challenge? I guess proven beyond a reasonable doubt means spewing forth incomprehensible legal opinions, however compare 26 USC 7201 with a real crime. 13-1102, negligent homicide classification. A person commits negligent homicide if with criminal negligence such person causes the death of another person. Negligent homicide is a class 4 felony, Arizona revised statutes. Providing a person caused the death of another person is certainly possible without this so-called law. Person A pointed a gun at person B's head and fired. Try making a case for tax evasion without a so-called tax code. Let's see person A earn $500,000 and put it in his pocket. Yeah, some crime. Shoot the bastard. He doesn't deserve a fair trial. Just in case anyone thinks I am advocating or believe people should not be held accountable for their actions, consider all I am doing here is using the so-called system against itself. I'm pointing out the contradictions and the inconsistencies. If some revenue agent forms an opinion, then that opinion is supposed to be the subject to the challenge, and it doesn't matter what the subject matter of the opinion is. For goodness sakes, even expert witnesses are subject to cross-examination. If you aren't supposed to challenge a revenue agent's legal opinion, then what is the point of having a tax court? If proving the law is binding is not relevant to proving tax evasion beyond a reasonable doubt, then bureaucrats could jerk some poor soul out of Fiji and convict them. In simpler terms, you could be convicted of not getting a dog license despite not having a dog. But, Your Honor, I don't have a dog. That's irrelevant. The statute requires every person to get the license. Then again, a dog without a license is a nullity. I really appreciate Mark Stevens' work, and I just wanted to share this with you. And I hope this, I'm going to stop reading at that point. I hope this encourages you to either look him up on YouTube. He reads his book out loud. I don't want to encroach on his intellectual property that he profits from. But I hope that you can see the mannerism and the humor, and it opens up the possibilities for you to broaden your mind and expand your thought process. He makes a lot of very, very poignant points, all while enjoying in some sarcasm. But the truth is, what he speaks of is so serious in nature, even though he makes light of it. Hundreds of thousands of people a day are subject to some guy in a black robe forming an opinion, calling it law, slamming the gavel down, and just blatantly extorting you for your wherewithal, all while they do nothing productive in society. I have said it 1,000 times now. There are not enough criminals in the United States of America to justify a courtroom in every county, or in every city, or in every town. And thus the legislator passes all these legislative rules that you allegedly are supposed to abide by. But the truth of the matter is, ladies and gentlemen, those men and women don't even abide by their own rules, statutes, codes, and provisions that they create. And because of that, it appears to just be nothing more than forced slavery, involuntary extortion, and things of that nature. It all boils down to responsibility. And a quid pro quo is in order. I would encourage everybody to start going to their courthouse and asking the clerk of the court, the clerk of the district court, the clerk of the county court, the treasurer's office. I want you guys to start asking for the CAFR report, the Foreign Registration Act of 1938. The CAFR report is the Comprehensive Annual Financial Report. And in this report, if you are capable of adding and subtracting, you will see the amount of wherewithal, credits, if you will, that are held on the public side that should rightfully be released to we the people. And in doing so, maybe you can help your community. I can't go and save the United States of America by myself. Can't do it. one thing I can do is affect positive change in the little tiny community that I'm currently passing through at this moment in time. And perhaps if we can get some unity here, we can help a lot more people. We're talking about abolishing property tax, abolishing income tax, because quite honestly, the corporation, they're the trustees. These people that work for us are the trustees of the corporation that we are invested in. And because of that, we're due and owing, ladies and gentlemen, and they're hiding these funds. And every year they raise your taxes, proclaiming that they don't have any money. I was just at a Valley County board meeting where they were, speaking that, oh, we don't have any funds. We don't have any money. We don't have any of this. We don't have any of that. I'm telling you, ladies and gentlemen, if we can expose the CAFR to the people that are sitting up there on those boards that have not a clue of what's really transpiring, we can make our communities better. And we can help free people that are financially just strapped to the gills and can't provide for their families any longer. We can help each other out if collectively we get together and start to open our minds and look at the relative possibility of what if this young man's correct? What if he has found something that we have all overlooked for a number of years? And what he is stating is true and correct. How much can we help our fellow man? How much can we help our fellow neighbor? In doing this, be careful, because when they reference us as the enemy of the state, they absolutely mean it. These bureaucrats don't want us to become educated because they like to run roughshod over us and they like to be in control. And by accessing these CAFRs and freeing and liberating the people of tax burdens and things of that nature, you'll find that your fellow man, your fellow neighbor is going to be a lot happier. He's going to be on less antidepressants. He's going to be leading a less stressful life, which in turn leads to a better community. And so pay attention, ladies and gentlemen. I hope you enjoyed Mark Stevens' Adventure in Legal Land. Again, I'm going to stop reading because it's his intellectual property. I believe he charges $100 for the book or something like that. If you get it, great. If you don't have those finances, I know that he reads it on an audio on YouTube. View his channel. The man is very poignant, very intelligent, and he's won a lot of cases, ladies and gentlemen. So with that, I'll yield the floor. Have a beautiful, blessed day, and think about approaching your council, your local city council members and your treasurers, and ask them about this CAFR report. Let's start hammering down on these people. Let's hit them where it hurts, because the only thing they care about is money, ladies and gentlemen, and money is non-existent anymore. This stuff is no longer in circulation. They don't use it. They use FRN notes, promises to pay, So let's go after this CAFR. Let's go back and take ownership of our estates, and let's make this this great nation great again. So with that, have a great day.